Hello there, good afternoon everyone. Welcome to the latest in Parker Bullen's webinars. This one's on director duties. Hope you're well. Thank you very much for taking time out of your busy day to join us. It's good to see you all today. My name's Andrew Marshall. I'll be your host for this short webinar. My job today is just to push the right buttons, ask any questions you might have, and generally keep things on the straight and narrow. If this is the first time you've been to one of our webinars, this is an informal chatty style webinar, so please get involved. Anyway, probably the best way to do so is to use the questions button at the bottom of the screen. Type in any questions you have and we'll try to answer as many of them as possible either during or at the end of the presentation. Before I hand over to today's presenters, we've got just a few items of housekeeping today. We're aiming for runtime of about 20 minutes or so with questions so probably might run up to about 30 minutes. We are recording the webinar, so the link will be shared afterwards. And we've also got a summary handout of the main talking points that we'll send to you after we're done. So the purpose of the webinar today is for us to share with you some useful information, practical tips and guidance on the topic of director duties. Just as a general disclaimer, any advice we will give is generic and shouldn't be relied upon unless you have spoken to us separately and we provided you with advice that is pertinent to your individual circumstances. So in today's webinar, we'll be talking about duties as a company director. And to present the topic, may I hand over to today's presenters. We have with us today Luke Wilkins, who is a trainee solicitor in our company and commercial team. And we have Rachel Munn, who's also a trainee solicitor in the same team. So without further ado, over to you, Luke and Rachel.
Thank you, Andrew. So my name's Rachel and I am a trainee solicitor in the corporate and commercial department here at Parker Bullen. And as Andrew said, I'll be hosting this webinar alongside Luke. So we'll begin this webinar by asking the question, wouldn't it be helpful to know what duties you owe to your company as a director and how you can protect yourself against a breach of these duties? In this webinar, Luke and I will be discussing exactly this, focusing on the duties owed by directors to their company, the dangers of breaching these duties, the main things that you should consider when making decisions as a director, and finally, some quick wins to avoid a breach of these duties. This webinar is important not just to ensure that you're aware of your duties as a director, but also to ensure that shareholders are aware of these duties so that they're able to identify them and to take the necessary steps to resolve them. I will now hand over to Luke, who will outline the main duties.
Hello everyone and welcome. My name's Luke. Thank you very much for introducing Rachel. So before we start to go through the duties, I just think it's important to note that these duties apply to all directors, whether you're a shareholder and a director in a one-man company, or whether you're a director in a big corporation. Your duties as a director will apply every time you make a decision in your capacity as a director. So it's really important that you know them. So we're going to go through each of these and just give you an idea and a flavour of what they're all about. So the first one is promote the success of the company. Now that's quite generic. What does it actually mean? Well, what we mean is you need to have some consideration for what the long and short-term effects are when you make a decision. You need to have some consideration of what are the implications for the employees of the company when you make this decision. What are the implications for the company's business relationships when you make this decision? All the things that would be promoting the success of the company, and you need to have consideration for all of these. Secondly, you need to act within your powers. Now, corporations have a specific structure in which decisions will be made, and usually this will be found in the Articles of Association of the company. So when you make a decision, it may be that actually you have authority to make the decision just under your general director abilities. You can just make it generally. It may be that actually you need to hold a board meeting and the decision needs to be done through a board meeting. It may be that actually the decision is such a big one, it needs to be made by shareholder resolution. So when you make these decisions, you need to ensure that you're doing so within your power as either a director generally, through a board meeting, or as your capacity as a shareholder. You also then have a duty to exercise independent judgment. Now, this would seem quite obvious, but it can go unnoticed. When you're making a decision, you cannot merely rubber stamp what other people say. You cannot merely say, oh, well, my other directors have said this, so I'm just going to go ahead. You need to actually put time and thought in, whether that's a third party who's advising you, another director, or a shareholder directly. You need to actually put your own spin on it and have dedicated time and thought into the decision you make. The easy way to think about this would be, you are trusted as a director to make decisions on behalf of the company. Therefore, it's you that they trust to make that decision, so you need to put that time in to make the decision. Fourthly, on today's list, we have exercise reasonable care, skill, and diligence. Now, what will constitute reasonable care, skill, and diligence will depend on how much experience you have, how long you've been a director for, and what previous experience you've got in that field. But ultimately, you just need to be careful, skillful, and diligent when you go about your day-to-day duties as a director. Number 5, you must avoid a conflict of interest. Now, this slightly links into the sixth one, which is not to accept benefits from third parties. When you're accepting a benefit from a third party, which, by the way, you're not supposed to do, you're indirectly giving yourself a conflict of interest. If you're receiving a third party benefit by virtue of being a director or by virtue of doing something in your capacity as director, you've given yourself a conflict of interest there. And finally, we have a duty to declare an interest in a proposed transaction or arrangement with the company. Now, an example of this would be where a company is selling perhaps some stock, perhaps they're selling their premises, or perhaps they're selling some machinery, and you actually want to go and buy that from the company. Well, in that proposed transaction, you clearly have an interest. So that is up to you to declare. And normally that would be done at the board meeting. So now that you know what your duties are, we need to know, why is this so important? Well, what are the dangers of me breaching that duty? And Rachel is about to go through that with you now. Over to you, Rachel.
Thank you. So as a director owes most of their duties to the company, if a duty is breached, it's the company which must bring an action against the director. However, in certain circumstances, a shareholder may bring a claim against the company on behalf of the company, provided they have suffered personal financial loss or damage. So consequences of a breach of duty may include removal from office. So the company's constitution determines how this process is carried out, but removal may be temporary pending further investigation or on a permanent basis. A director can be disqualified for breach of duty, following which it would be a criminal offence for them to be engaged in the management of a company or limited liability partnership without the permission of the court. If this happens, it can therefore have very serious consequences for their individual career and company life. Another consequence of a breach of duty is that it may set aside transactions between the company and another company or client. This will have a negative impact not only directly on company profits, but also on wider publicity for the company and further business. Another danger of a breach of duty is that the director may be liable to pay damages or compensation for financial losses incurred. You may think that the company will not take action against you. However, this is particularly dangerous in the event of insolvency or liquidation, as the company's management would be taken over by an administrator or liquidator, and it would be their duty to bring proceedings against you if you've been in breach of duty. This can ultimately result in personal bankruptcy, as you will be held personally liable in the event of insolvency or liquidation if in breach of duty. If the company does become insolvent, or it seems that the company may become insolvent, it is essential that directors seek professional legal and accounting advice before continuing to trade. A further danger of breach of duty is criminal fines. So some breaches, such as failing to file accounts or annual returns, are criminal offences for which you the other directors, and the company could be fined. You must do everything that you can in your power as director to make sure that these things are done properly to avoid falling foul of this duty. Finally, there may be a danger that the director may be required to return company property which they obtained as a result of the breach, or a court order be made against the director to prevent them commencing or continuing a breach, known as an injunction. This would be issued by the court with the intention of halting any ongoing actions in breach of director duties. It serves to reduce the potential for further financial loss and prevent irreversible damage to the company. I will now hand over to Luke again, who will talk you through the main considerations you should have when making decisions as a director.
Thank you, Rachel. So now that we know what the duties are and we know what the dangers are for breaching those duties, now we need to think about, well, what is it that we can do to prevent a breach of duty from happening so that we never get put in that situation? Well, there are a couple of things that we think that you should consider, and this is on a day-to-day basis when you go about doing your business. Number one, assess whether you have any conflicts of interest before proceeding with transactions. Now, this could be quite a simple exercise and quite quick. Do I have any interest in the proposed transaction that's about to happen? Well, no, I don't. But then again, it may be quite complex. It may be that you have family members or you have close friends that have a stake in a company that you're dealing with, or perhaps they themselves own and are transferring to you property in exchange for money. So it can be a more complex procedure to think about whether you have conflicts of interest. Number two, are you exercising independent judgment and are you making your own decisions, or are you simply following the decisions of a third party? This again should be quite straightforward. Just have in the back of your mind, actually, have I given some thought to this myself, or am I just going along with what other people have said? It's really important that you take the time out of your day to think about and go through things yourself, which is probably something you already do. And finally, does the activity or the proposed transaction promote the success of the company? Now, this isn't just simply saying, oh, well, is this in the company's best interests in general? Well, you might think it is, but is it in the best interest of the company in terms of the long-term consequences, in terms of the effect it's going to have on the company's employees, in terms of how it will affect the company's business relationships, in terms of how it will affect the community and the environment? These are also all things that need to be considered, and you have to go through all of these things. Now, I'm not saying that for every decision you ever make, you have to have a long list of things you go through, but having this all in the back of your mind and having the knowledge will actually help you in the future, because you can think, oh, hang on, I'm not sure about this. I need to think about this more. And that's why we're going through this now, so that we can help you to consider these things in the future. Now, Rachel's going to go through some quick wins for you. Handing over to you, Rachel.
Thank you. So the first quick win we have is to record all board meetings and keep up-to-date records of board meetings, accounts, annual returns, and all other information required by Companies House. This is really important, especially if there are disputes in the future, as you'll have detailed and up-to-date records of all information required, which will enable you to avoid liability and protect both yourself and your company. It may well be that you've complied fully with all the duties required of you, which I'm sure you will do. But if you've not taken and recorded adequate notes of all decisions made and any other important information, then you may potentially find yourself in a tricky legal position in the event of a dispute. Drafting board minutes and ensuring that you use company procedure properly to implement decisions are types of things that we can advise you on should you require it. The second quick win we have for you is to step back and consider whether the activity is in the company's interest or your personal interest. If you're not certain that a proposed transaction or activity promotes the success of the company, we would strongly advise you to hold off agreeing to anything until you have considered it fully or sought independent legal advice should you feel that you need it, to avoid falling foul of this duty. This is again something that we would be more than happy to advise you on. The third quick win we have for you today is that companies should ensure that all directors are aware of their duties. As a director, if you feel unsure about any of the duties you owe to your company, or how to ensure that you do not fall foul of any of these duties, then we would recommend taking positive steps to ensure both yourself and your fellow directors are aware of them, how best to comply, and the dangers of non-compliance. It's important to remember that breaches of duty do not only occur through positive acts of misconduct, but also through being purely unaware of what the duties are and what's required of you as a director. So for example, it may be that a director is wanting to enter into a transaction with a company or companies, which may give rise to a potential conflict of interest, or where they're required to declare an interest in the proposed transaction, but be purely unaware of this and therefore potentially be in breach. So it would be worth making a conscious effort to remind both yourself and your fellow directors of their obligations on a regular basis to avoid any unnecessary breaches and to enable them to clearly identify situations which may give rise to potential breaches. The final quick win we have for you today is to remember that as a director, you will always be held accountable for your actions. This is extremely important. Every time you make a decision on behalf of the company, ensure that you are fully fulfilling the duties that are required of you as a director, and either do not act or ensure that you seek independent legal advice if you are not confident that you are. I will now hand over to Luke to conclude today's webinar. Thank you all for taking the time to attend, and I hope you found this useful and informative.
Thank you, Rachel. So we've gone through what the duties are. We've talked about the dangers of if you breach a director's duty. We've then talked about the things that you should consider. And then we've taken you through a couple of quick wins just to ensure that you avoid breaching a duty. We have our contact information on this slide here. So if you do have any questions, please do get in touch. And I think, Andrew, if there are any questions, we'll take those now, please. Thank you very much, everyone.
Thank you very much indeed, Luke and Rachel. Some genuinely really interesting points to be had there. Right, yes, if anyone watching does have any questions, now is the time. Just hit that button at the bottom there. We do have a couple of ones that had been sent in previously in anticipation. We've got one from James here. Can you expand more on what a conflict of interest is?
I'll take that one, Rachel, if you don't mind.
Yeah.
So a conflict of interest, that can arise in a couple of ways, actually. So a conflict of interest could arise where well, essentially, you and the company have interests that differ. So potentially, we've spoken about already where you're buying something from the company wants to sell it to you at the highest price possible, but you want to buy it for the lowest price possible. What else is there? So, potentially when it's not you, but it could be a close family member, it could be a close friend, or it could be something like a company that you own. If you own a company and you're a director in a different company and they engage together in relations, then there could potentially be a conflict of interest there as well. I think another thing that's important to recognize is you do have a duty to avoid conflicts of interest, but that doesn't always mean that you can't act. The board can authorize you to still make decisions on behalf of the company if they think that that conflict of interest, will not actually lead to a problem in the future. So it's important to explore that, because actually you may be uncertain, but it may turn out to be all right, or you may be uncertain and you may be right, but your gut feeling may be correct. So if you have any more questions about that and you want specific answers, please get in touch.
Excellent stuff. Okay, I think we had one other question that had been sent in beforehand. This one's from Charles. as a director of a company, what steps should I take to ensure that my fellow directors are fully aware of their duties and are complying with them?
Yep, so I'll take this one, if that's okay, Luke.
Yeah.
So thank you, Charles, for your question. So I would recommend ensuring that all directors receive a hard copy of the duties that are owed by them. This will enable them to have easy access to refer when making big decisions and be able to check this. And I would also advise you to raise the director's duties maybe at regular meetings that you have, so that directors are confident on what's required of them. And this will give them the opportunity to think about them and also to raise questions if they're unsure, just so that the duties are constantly in the director's mind to ensure that there's no breaches due to being unaware of them.
Brilliant. Right, I think, just have a quick look. And yes, that's the end of the questions that we've come through. Brilliant. Well, thank you again, both to Luke and Rachel, for fantastic presentation. Thank you everyone watching. We really hope you found that useful. Just a reminder, you'll be sent a link to the recording, the email address you've been provided, along with a summary handout of the main talking points from today's webinar. If you do have any queries about anything we've discussed, or if you would like any tailored advice on the topics that we covered, please do get in touch there. Got all of our details on screen right there. Until next time, thank you very much, and we look forward to seeing you all again. For now, enjoy the rest of your day.
Thank you very much for attending.
Thank you, everyone.
Thank you very much.